the Bills of Sale Act, 18th of June, 1867. Short title. This act may be cited as the Bills of Sales Act. Section 2. Interpretation. Subsection 1. In this act, bill of sale includes bills of sale, assignments, transfers, declarations of trust without transfer, and other assurances of personal chattels, and also powers of attorney, associates or licenses to take possession or personal chattels as security for any debt, but shall not include the following documents, that is to say, assignments for the benefit of the creditors of the person making or giving the same, marriage settlements, transfers of assignments of any ship or vessel or any share thereof, transfers of goods in the ordinary course of business or any trade or calling, bills of sale of any goods in foreign ports or in foreign parts or at sea, bills of landing, warehouse keeping, certificates, warrants or orders for the delivery of goods, or any other documents used in the ordinary course of business as proof of possession or control of goods, or authorizing or purporting to authorize, either by endorsement or by delivery, the possessor of such document to transfer or to receive goods thereby represented. Personal chattels means goods, or chattels means goods, furniture, fixtures, and other articles capable of complete transfer by delivery, and shall not include chattels interest in or chattel interests in real estate, nor shares or interests in the stock, funds, or securities of any government, or in the capital or property of any incorporated or joint stock company, nor chooses in action, nor any stock or produce upon any plantation or lands which by virtue of any covenant or agreement or custom of the contrary are not to be removed from any plantation where the same are at the time of making or giving such bill of sale. Subsection 2. In this act, personal chattels shall be deemed to be in the apparent possession of the person making or giving the bill of sale, so long as they shall remain or be in or upon any house, mill, warehouse, building, work, yard, land, or other premises occupied by him, or they shall be used and enjoyed by him in any place whatsoever, notwithstanding the formal possession thereof may be taken by or given to other person. Section 3. Bill of sale of personal chattels to be voided if not recorded. Every bill of sale of personal chattels made either absolutely or conditionally, or subject or not subject to any trust, and whereby the guarantee or holder shall have power, either with or without notice, and either immediately after making the said bill of sale, or at any future time to take possession of any property and effects comprised in or make subject to such bill of sale and every schedule or inventory which shall be thereto annexed or therein referred to, and every attestation of the execution thereof, together with an affidavit of the time of such bill of sale being made or given, and a description of the residence and occupation witness thereto, or in case the same shall be made or given by any person under in execution of any process, than a description of the residence and occupation of the person against whom possession shall have issued, and of attesting witness shall be recorded at length in the record office within 30 days after the making or giving of such bill of sale, in like manner as deed relating to real property in this island are recorded. Otherwise, such bill of sale as against all assignee of the estate and effects of the person whose goods or any of them are comprised in such bill of sale under the law relating to bankruptcy or insolvency, or under any such assignment for the benefit of the creditors of such person, and as against the bailiff of the court and his deputies and assistants and any and other person seizing any property or effect comprised in such bill of sale, in the execution of any process of any court of law or equity authorizing the seizure of the goods of the person by whom or of whose goods such bill of sale shall have been made, and against every such person on whose behalf such process shall have been issued, shall be null and void to all intents and purposes whatsoever, so far as regards the property in or the right to the possession of any personal chattels comprised in such bill of sale which, at or after the time of such bankruptcy or declaration of insolvency, or of the execution of the debtor of such assignment for the benefit of his creditors, or of executing such process as the case may be, and after the expiration of the said period of 30 days, shall be in the possession or apparent possession of the person making such bill of sale, or of any person against whom the process have sued or have issued under or in execution of such bill of sale shall have been made, as the case may be. I will check. This is all of this is one sentence. Remember, this law was written before, well, this law was written in 1867. As for the reason of why they are written in this cumbersome way, that is another matter. But we continue. But let me review parts of section 3 again. Any bill of sales. Any bill of sale. Any bill of sale. That's the main point here. it says here, or this or that are made subject to any bill of sale, or this and or that, and every attestation of the execution thereof, together with this and that, or in the same shall be, and it goes on, shall be recorded at length in the record office within 30 days after the making and giving of such bill of sale. So this, all this seems to be saying is that this bill of sale, every bill of sale under these circumstances shall be recorded in the records office within 30 days after the making or giving of such bill of sale. Then it continues. Otherwise, such bill of sale as against all assignee of estate, and so on and so forth. We go on. Such bill of sale, and after the expiration, okay, at or after the time of such bankruptcy, if there is a bankrupt, or declaration of insolvency, or apparent possession of making such bill of sale. So you see, it is quite wordy. One long sentence that, in my opinion, is unclear and not properly made, and could be put in a much clearer way. But anyway, Section 4. If such bill of sale shall be made or be given, subject to any defiances or condition or declaration of trust not contained in the body thereof, such defiances or condition or declaration of trust shall for the purposes of this act be made as part of such bill of sale, and shall be written in the same, on the same paper or parchment on which such bill of sale shall be written before the time when the same shall be recorded. So if such bill of sale shall be made or given, such defiance or condition, so if there is condition to it, if there is some condition that should be satisfied, it shall be written on the same paper on which such bill of sale shall be written before the time when the same shall be recorded. So the bill of sale was recorded, and then, well, before the time when the same shall be recorded. Okay, so the condition should be written before the time it was recorded. Otherwise, such bill of sale shall be null and void to all intents and purposes against the same persons. Is Section 4. Defiance or condition of bill of sales to be written on the same paper with the bill of sale. And as regards the same property and effects as if such bill of sale had not been recorded according to the provisions of this Act. Section 5. On payment of debt, satisfaction to be entered. On the debt, if any, for which any bill of sale as aforesaid shall have been made or given, being satisfied or discharged, the grantee or holder of such bill of sale shall cause satisfaction to be entered on the margin of the record of the said bill of sale in the records office Otherwise, it shall be lawful for any judge or Supreme Court, on proof of the satisfaction or discharge of the said debt, to order a memorandum of satisfaction to be so entered upon the margin of the said record of the said bill of sale. So they seem to be saying, if you have a bill of sale where someone must pay you, when you are paid, you must indicate on the paper that you have been paid, that the payment was made. If it was not made and the matter is brought to court, it shall be lawful for any judge of the Supreme Court, on proof of the satisfaction, upon proof that you were indeed paid, to order that you produce a memorandum of satisfaction to be entered upon the margin of the record of the said bill of sale. Alright, so that was the Bill of Sales Act.